right, thanks for coming upstairs. We have the artist formerly known as Paul.com, now working for Security Weekly, and he's going to talk a really interesting story about hacking the U.S. trademark system. I actually wanted to introduce this talk just because I wanted to see it, so this is going to be pretty cool, and I'm just going to hand it over to you guys and let you run with it.
Awesome. Thanks so much, Rob. Welcome, everyone. Thanks for coming. As Rob said, I'm Paul Asadoorian. My full-time job is I work for Tenable Network Security. I've done this part-time thing, primarily a podcast that was called Paul.com. It's now called Security Weekly. And many of you still ask, well, how did that come to be? And so my good friend Kas, who's also my lawyer, and also Batman, is here to tell you how all that transpired. Kas, thank you for coming out.
No, it's my great pleasure. So, as he said, I am a business lawyer. My specialty is in corporate law, but I have a niche in intellectual property, which includes trademarks. And so we'll get into this more in detail in a few minutes, but Paul and I originally started working together because he had an idea that he wanted to trademark a name that he'd been using in business, Paul.com, and I said, sure, let's look into that and see what happens. And the story of what ultimately evolved from that very simple conversation is kind of why we're here today. So the Batman illusion, most of my clients actually do know me as Batman. I answer the phone occasionally as Batman. It's a long story, childhood.
We have pictures, don't worry.
Well, yeah, it's a bit pathetic, actually. But in true geek cred, I actually own every Batman comic book back to 1951 in a straight line, and then a smattering about 40 or 50 between then and number 1. With my earliest being number 7. So I just wanted to put that out there. There's a reason for this. So
it's nerdy more than geeky. I wrote a disclaimer, and then I showed it to Kas. We have the benefit of we had an actual attorney look at our disclaimer for this talk. So I want to read it out loud for the recording. We respectfully request, no, seriously, the community not engage in any behaviors of retribution such as DOS, DDoS, doxing, swatting, defacing, trolling, mocking, any other related or even unrelated behaviors towards any of the individuals that will not be named, but whose identity could be derived using the skills you already likely possess. This presentation is for educational purposes only. I wanted to make sure we covered that in the very beginning. Ben, yes, already you have a question. What's that? What typo? Did I make a typo?
Possess.
Where?
Possess. Mispronounced. Last word.
Oh, you wordsmithy, you.
I can't believe I didn't catch that.
Yeah, it wasn't a real. It wasn't a question. It was obnoxious. Thanks, Ben. So I described a little bit about me. Here's a little bit about Kas. Pretty much we summed it up. He loves Batman. Legal stuff is better with cigars, I find, anyway. And he knows Kung Fu. So it's funny when I don't know if it's necessarily all over yet, but when we got to the end of this journey, or near the end, we were like, well, I was like, Kas, have you ever, this happen all the time? He's like, no. I'm like, has this ever really transpired the way it transpired? He's like, well, no. I'm like, we should do a talk. And it's really kind of therapeutic for me to share my experiences in the hopes that when you name something, as we'll talk about here, right, we're a community that we name a lot of stuff. And I want to make sure that everyone in the community is afforded as much protection as you can from your names. So another reason why this talk, right? So after about 10 episodes of my first podcast, I got a call about my domain name, and we'll go into what transpired there. Over the years, folks were confused. There was nominal confusion between the Paul, so there's a couple things. We'll call it Paul.com, and that's the site that is owned by someone we'll call Bob, okay? And me, which is Paul.com, or we'll call me Paul.com, right there. Paul, perfect. Paul.com, Bob, Paul.com, me. So this escalated once I got the initial call. I filed the trademark application. After roughly a 2-year process, I forfeited the trademark Paul.com. and changed my name to Security Weekly. But to understand how we got here, I wanted to understand a little bit of the history. First, a little more on why this talk. We realized there's a lot of lessons to be learned about trademarking your own projects. Like I said, this community is awesome, right? We're all friends. We all have lots of projects. We all have lots of ambitions. How many people in here have a blog of some kind, or podcast, or some kind of media outlet, right? Quite a few people in here. So when you name, how many people have written their own software and published it open source or not, right? A couple of people in here. Our community is always naming things, right? And I want to make sure that we understand this case as an example of the naming process, so that you can come out and not have to have any headaches, because I mean, parts were not fun in this whole process. It was pretty stressful for me, my family, for Kaz, because I was constantly calling Kaz and in a lot of stress. And he coached me through all that. So Kaz, you had I think the second one here.
Yeah, well, I mean, I think it's probably a good chance for me to step in now and start at the very basics of what it is we're talking about. Almost everyone knows the catchphrase intellectual property, of which a subset of that is a trademark. Basically, in the United States, there are other national and international ways to do this, but in the U.S., United States trademark law is policed by the United States Patent and Trademark Office. It's federal law, and their fundamental purpose is to make sure that if someone is out there with a brand name, fundamentally that's what a trademark is a brand name under which you are doing some sort of business, whether it be a podcast, or selling a service, or selling a product. There are also service names, same idea. Trademark, service mark, it's basically the same thing for the purposes of this conversation. And the United States Patent and Trademark Office, back in the early part of the last century, realized that what people were doing is, if there was any successful business out there, let's say Coca-Cola, that had any kind of market share, immediately other people would come up and they would copy that name with just slight variances. They'd do Coca-Cola with a K instead of C-Coca, C-Cola. And then they would try and sell that product out there, specifically trying to fool the consumer into thinking that their second product was actually the first product. And so they were marketing their product on the coattails of someone that had out there and actually developed it. Now, why is that a bad thing? Fundamentally, as a matter of public policy, a lot of these secondary products were often unsafe. They hadn't gone through the same kind of testing or whatnot as the original had, and so consumers were using these products. A soda is probably a good example. If someone's out there creating, and again, we're talking about 1910, 1915, whatever, some product that doesn't actually have proper safety protocols for clean water or whatever, consumers are buying it thinking it's one thing, it's another. It's a problem. Ultimately, this is now developed into a completely different purpose. And the purpose is that we, as business people, as people putting a product out there, believe and understand that the names under which we operate our business or services in and of themselves have a value. And we don't want people out there pretending to be us in order to fool our constituents. Hence, trademark law. When you go out there and you decide that you're going to have a business, a service, whatever, and you want to make sure that you're unique in the marketplace, one of the best ways to do that is to file a federal trademark application. And part of that process is that people like me will go out there and make sure, hopefully at the beginning end of whatever business or service you're doing, that there's not already somebody out there that's got a name like yours. This situation is exactly what happened to Paul, where Paul.com and Paul.com were existing simultaneously in the marketplace and started to cause some problems. So I'll let Paul get into more detail about what exactly some of those initial problems were, but our first order of business, when he called me, I said, well, let's see if we can file a trademark. Yeah?
This trademark thing is only within the U.S.?
No, that's a very good question.
Yeah.
So many other nations have their own patent. I'm sorry, yes, the question is this trademark thing only in the United States? And the answer is no. Many other countries The European Union doesn't have one that's functional, but many countries within the European Union have their own patent and trademark system. China has its own patent and trademark system. And one of the determinations that we make as trademark professionals is whether or not it's worth the money to go out and actually file in Sweden and France and Germany and Spain and Portugal and Italy and China and India.
I asked that question of Kaz. I'm like, so can we like go international with some of the trademarks that, well, one that we filed for and have gotten successfully, and others that we're pursuing, and it was interesting to hear your advice on that.
The answer to that question is that in most industries, your constituency, the people that have the money to pay for your services and your products, are in the United States. This is the market, basically. That's not true for every product, but it's true for most products. Now, the question that you have to ask yourself is, if someone copies your, do you have a business, any business name, any business?
Mabuhay Enterprises Incorporated.
Great. What was it?
Mabuhay Enterprises.
Mabuhay Enterprises Incorporated. Excellent. Let's say you find out that someone in northern China is operating under the name Mabuhay Enterprises Incorporated. My question to you is, are you really, seriously wanting me to go to China, hire a Chinese attorney or Chinese lawyer's firm to sue that person to get them to stop doing that? Is it that important to you for the market that they're likely to steal from you in your business? Depending on your business, the answer may be yes.
Yeah, Microsoft, Disney,
sure,
Google,
Coca-Cola,
Nike,
Marvel, any of the major movie production companies where these films are getting like pirated, mass market piracy in China. Yeah, they've gone out there and started saying, hey, wait a minute, you can't do that. But the vast majority, I make up a number, 99% of businesses, frankly, don't care. And so I will tell you, my strong advice is yeah, I can charge you a couple of $1,000s to file a trademark in China. Frankly, you're not going to enforce it. You're not going to. It might have a prophylactic effect to prevent someone in China from actually using your business name, but in most cases it doesn't matter. The market that most people are looking for is right here in the United States. Depending on my client, sometimes people are based in a specific country. I have a client in Sweden, I work with several people in Australia, and they'll want their country and the United States, and we can do that. But generally speaking, it's a rare animal that actually goes out there and tries to blanket the world with a trademark on whatever their brand happens to be. It's a great question.
I wanted to start with some of the history, and it still took some time for Kaz and myself to put together this history. There was a lot of digging around on the Internet Archive. There's a lot of digging around in emails and documents that we had. So this is kind of the consolidated Cliff Notes version, if you will, of the history. So it starts in 1994. Some guy, we're going to call him Fred. So Fred is how we'll address the original owner of Paul.com, Fred registered Paul.com in 1994, and to speak to how he used it, and you'll see more examples over time, primarily in 1994, he stated on his website he used it for his email address, hockey facts, and gaming, and the title bar read Paul DOTCOM in the title bar, and that was 1994 as the first inception of the Paul.com website. In 2000, I'm given the nickname of Paul.com, Paul.com, because, well, basically I'm a nerd. I email Fred.
Let me interrupt you for just a second.
Go ahead.
The use in 1994, just remember that. Hockey facts, gaming, email address, because that's important. Remember what he was using it for.
We'll explain why that's important. Yeah. So I email Fred and I say, "Hey, would you be willing to sell me the domain?" He replies that he's only accepting serious offers for the purchase of the domain. I have no record of the communication, and we'll qualify what serious offer means in future slides as well, and go into a little more details of some of the things that Fred's website read. In March of 2000, I registered PaulDOTCOM.com because everyone's still calling me that, and nerds own things like domains like that. So, in May,
let me step in again for a second, if I can. Can you do the previous slide?
Sure.
And that was before I got involved when he registered Paul.com. And
.com.
Sorry, Paul.com.com. And one of my jobs, if you will, as a trademark attorney would have been hopefully to figure out when he registered in 2000 that there was something from 1994, Paul.com, and at least to put on his radar, A, the U.S. Patent and Trademark Office may not let you trademark that. If they find that those two names are too similar so as to create confusion in the market, they may just neg you from the outset. But it's different enough that I probably would have advised him, let's swing. Let's swing at the ball. Maybe we knock it over the fence, maybe we strike out, but let's see what happens. So I got involved later, but at this point,
So one of the, and Kaz will explain why this is important a little later on, but in May 2003 I published a paper at the Sands Institute under the name Paul DOTCOM with my email address and my website to compare the two sites in roughly that same time frame. Fred's website, which was Paul.com, read that Paul.com is used for email and occasional personal project stuff. There's probably very little to see here. He said he's a producer at a gaming company and links to his bio page. So Fred's position in 2003 that he stated publicly is that the amount of money he wishes to receive in exchange for the domain has to put him most of the way into an Audi at that time. I'm not making that up. I'm not speculating. It's actually what his website says right here. Yeah, from the Internet Archive. That's the screenshot. You can go look it up. He plays Dungeons and Dragons and goes to Dragon Con. At this point, I really just consider burning my nerd card because I'm clearly inferior and depressed at this point. But basically, he says how much for your domain is what it says here. He says he gets asked that, and the short answer is he's not looking to sell. But if you must make me an offer, then send it. I'll have to be most of the way into one of these, which is a link to Audi's website. So that was Fred's position in 2003. In 2003, my website reads, many people ask where Paul.com comes from. It's because I'm a nerd. A friend of mine just blurted it out. You may also be wondering why I didn't register Paul.com. I've tried many times to purchase it from Fred and finally gave up. And one of the reasons I gave up, and there's more evidence of that as we move forward, but one of the reasons I gave up was because I couldn't put him most of the way into an Audi for the site. And I asked people to visit his website and send him email and tell him why I should have it instead of him. In retrospect, I probably shouldn't have put that there. But
that was not my advice.
It was not. Kaz advised against that. But some of the reasons that stemmed from my frustration was, this is in 2004. Fred's website reads, question, can I buy Paul.com? Answer, probably not. Okay, so that means it wasn't for sale. I was moving on with my domain and happy with the Paul DOTCOM. Let's just go back to this for a second. Can I buy Paul.com? Probably not. Okay. Then in 2005, Paul.com was sold. But probably not, right? Not. Paul.com was sold. Turns out someone wanted it, and it was sold to someone that we'll call Bob in this presentation in 2005. You might remember him from slide 5. Bob purchased the domain from Fred allegedly for $21,500. In 2005.
I can't back that up. By the way, I don't know what the actual purchase price was. In fairness,
it was in some of the documentation, but again, it's speculation. We prefaced that with the word allegedly. I haven't seen evidence of that, but hard evidence of that. But there is claims that it was allegedly sold for $21,500.
A possible legal nomenclature for that would be bullshit, but I don't know. Having said that, if he got that for it, great. That is potentially at least a good way of the way into an Audi. So good for him.
Yeah. So in August of 2005, ownership has completely changed hands to Bob, who is the new owner of Paul.com. I remember visiting the website, and I pulled from the archives that Bob's website redirects to a completely different domain. and reads this. Basically, managing and building great software is hard, so this is a consulting company in which we can help you specializing in branding and product management. Okay? And this is important, as you'll see, it didn't conflict at this time, in my opinion, and again, I'm not an attorney, Kaz is the attorney, right? It didn't conflict with what I was doing. It didn't look like we're doing the same thing. He says that there are companies specializing in brand, product, and product management. You know, I'm a hacker, I had a podcast, and we talked about computer security and security consulting. That's what we did in 2005. Even before we started the podcast, I was publishing research in computer security.
Right now you're asking yourself why. Why is that an important distinction? And the answer is because under American trademark law, when you file a trademark, you get to choose which channels of commerce your trademark is protecting. Okay? So if with some exceptions, and I'll talk about that in just a second, with some exceptions, if you're a computer security person, there is a list of literally thousands of different descriptions of trade channels, which include computer security, women's shoes, video games, furniture, paint, whatever.
Important point to that is that there can be two trademarks that are exactly the same.
That's right.
In different channels.
Can
anyone give me an example?
WWF.
Wasn't that yeah, but I think they won that, didn't they? And they had to change their name, so probably not the best example.
Sorry.
That's okay. Anyone else? Two trademarks that are exactly the same, but in two completely different channels, as Kaz described.
Apple Computer and Apple Records.
Sure.
Perfect.
My favorite example is Dove chocolate and Dove soap, right? Does that get my attorney's approval?
That's exactly right. That's exactly right. You could file a trademark for Dove chocolate, and I assure you there's a filed trademark for Dove soap. But because they do different things, the U.S. Patent and Trademark Office says, well, that's not, if someone's trying to buy soap, they're not going to accidentally buy your chocolate and wash with it, right? I mean, that's
You'd be surprised what you can find on the internet, Cass.
That's a different channel altogether.
Those domains end in .xxx now, though.
I need to say there are some exceptions to that. There are some brands in the United States that have been given sort of a super trademark status where the name or the symbol used by that brand is so cooked into the product that the U.S. Patent and Trademark Office will not let you even sell other products under that brand.
Can anyone give an example of that? What do you think?
Marvel, the Disney ears, the Nike swoosh, the name
Something
Nike.
used to search, right? Yeah, there can only be one Google.
A big one that is starting to fall off the radar, this is interesting because you can gain super status and then lose it, is Xerox. For a long time, Xerox was a trademark that you couldn't use anything else for because to Xerox meant to photocopy. Now that technology is starting to slide off the map, and I have discussions with my other geeky lawyer friends about whether or not we could sneak a Xerox trademark. This is the stuff that amuses us. But the point is that when you pick your trademark, you pick what area of commerce you want. You can pick multiples, but you're going to pay for every one. So you decide. And part of my job is to tell you, well, given my understanding of your business, this is the universe that I think we should be trying to protect. And let's see if we can do that. Okay? So it's relevant that before, Paul.com was my personal projects and gaming. Now it's shifted to product placement. Just bear that in mind.
One of the other interesting facts, I happened to mention this in casual conversation to a friend of mine, and he said, well, Bob's office is in Boca Raton, Florida. And I said, yeah. And he goes, well, of course it is. He's like, that was dubbed Maggot Mile. And I'm like, what? Like Google search, what is this? So it turns out, as I said, Bob's business, who's the person that purchased Paul.com, is in Boca Raton, Florida. Now, Florida state investigators dubbed that area Maggot Mile circa 1992. It still kind of bears that, people still refer to it as that. You can read articles, all the way as early as 2012 that are still referring to that area as Maggot Mile. There are certain, I want to say, tax benefits for businesses to be in Boca Raton, Florida, and it has a history of a a lot of scams. There was a certain percentage, over 60% of the world's spam at one time was originating from Boca Raton, Florida.
I'm going to protect our butt here and say that the suggestion is that Bob might be a scammer. It's just as likely that Bob's family's from Boca Raton. We have no idea, but it's just a point of interest that his business happened to be located in that place that happens to be known for more rather than less seedy business practices. Enough said.
So, thanks, Cass.
Got your back.
In October of 2005, the first episode of Paul.com Security Weekly is released. Now, an interesting thing that I've never talked about publicly before is in December of 2005, Bob called me and said, hey, I'd like to purchase your domain, pauldotcom.com from you, and I'll give you $1,000. And I thought at the time and considered it for all of 30 seconds that I spent thinking about that, and I said, well, I've already released a bunch of episodes of this Paul.com Security Weekly podcast. I really don't want to have to rebrand at this point, so I think I'm just going to keep my domain. So now I wanted to stop for your first lessons learned. If my hindsight was in fact 20/20 and I could go back in time, I probably would have made a different decision considering the events that have transpired since then. But it's important, I think, to note a couple of things on this issue, right? First, if you're in the early stages of creating a product and have a domain name or certain names or whatever, and someone offers you money for that.
Early stages meaning you don't have a lot of brand recognition in public yet.
Right. You've just bought the name, maybe you started working on something, you're going to call it something, and someone really wants that, wants to give you money for it. My advice is you might want to really seriously consider taking the money and running, because there's your startup capital, or at least some of your startup capital for that project. In my case, I probably could have done that. Another great example, many of you know I'm in the cigar industry. We do a cigar internet TV show and podcast called Stogie Geeks. So that namespace is very oversubscribed. It is very tough to get a unique name in that space. So I've bought up some intellectual property or names in that space. And there was someone who just started a particular project and hadn't really released anything. He said, no, I'm really not interested in selling. I said, well, I could tell you this whole story about this Paul.com thing, but then 6 months later he came back and he said, you know what, I think I am willing to sell. So I bought up his namespace for like $1,200, I think is what I paid for the namespace, and that's hugely valuable to me. And now he's got $1,200 to go start up something new, which was just some of my advice for everyone. Kaz, you've got a different kind of spin on that?
Well, I mean, no. Paul said exactly what my opinion is if you've got a name out there and you don't have a lot of value in it yet, and someone comes and offers you a sizable chunk of change, you should consider it, because cash is king, bird in the hand, and all that. However, I made Paul add the subpart B under bullet number 1.
Yeah.
Maybe, under no circumstances should you sell your domain name. Why not? Well, I keep track of these things. This is a little bit dated, but
this has been escalating even since we started working together, actually.
Toys.com sold at auction in 2009 for $5.1 million. Slots.com, 2010, $5.5 million. Let's move up a couple of years. 2006, Diamond.com sold, $7.5 million. 2010, FB.com, Facebook, $8.5 million for the domain name. More recently, 2009, Insure, with an I as in insurance, Insure.com, $16 million for the domain name. Relatively recently, VacationRentals.com, $35 million for the domain name. So if you have something that is particularly like a normal word, a word in the dictionary, I dare you to find one. You might want to hang on to it, because at some point that could have real value. But
why do all these Web 2.0 sites come out and they leave the E out and they have Flickr? Why is that, Kaz?
Well, because Flickr's not in the dictionary. And someone intelligently went out and said, you know what, we're going to spell Flickr with no E in it, so it's not a word. And then they created the brand name. They created the value in that. That meant nothing before they did it. Now, what is Flickr worth now? I mean, who knows? The ones that are actual words, even obscure words, You're all techies. You know what the word Google means, right? Take a wild guess at what Google.com could be worth in today's market. Right? I mean, I don't know. $10 billion. I have no idea what they'd sell that for.
You'd be better off.
You can't buy it. They have more money than any. But why? They'd be like, no, we don't need the money.
You'd be better off going to buy an island or something.
That's exactly right. I would take that money and do
But
something
Google's
else.
probably the best example, right, of a name that meant nothing and they created their own brand.
There was one recently, Kitchen.com. I think. I mean, this made NPR. I don't remember what the number was. I think it was Kitchen.com. Look it up. These things are hugely valuable. But now, 2005. Paul.com. I mean, who knows? The question is that public information? What domain names have sold and for what? Yeah, you can run it down.
Probably not in all cases, though.
Yeah, so I mean, a lot of them are private sales, but particularly if it's a publicly traded company, that is very much public information. You can look it up on the SEC's website, Securities Exchange Commission. So. And a lot of them, I mean, if it's big dollar numbers, these are starting to go at auctions now. Like Christie's will sell these. Just to a Google search will often pull up what kind of numbers people are talking about. That was a great question. A better question is how do I value my domain name today? What could I get for it? That's more art than science.
Yeah.
I mean, I could give you a read on it. Oh, absolutely. You guys have heard of, the question is there a business in that? You've heard of patent trolls? There are trademark trolls who sit on these names for just that reason.
Will they help you understand what the value of your domain is worth?
Well, ultimately, the question is will they help you understand what the value of a domain name is worth? The real answer to that question is that the value of any given domain name is simply this: what someone is willing to pay for it. Period. And that could be different today than tomorrow. I don't know.
You don't know until you don't tell us.
No idea. Me, if I were in the, and for the record, I'm not in the business of selling domain names. I'll register you, but that's a different business altogether. Having said that, I, based on the strength of the domain name, would try and pitch it to as publicly known a market as I possibly could, like a Christie's or someone like that, because the generally thought being the more people that know about it, the more likely you are to get a bidding stream and to get the money up, even though you'll spend more for someone like a Christie's to bid your name off.
So there's someone at Christie's and their job is to determine whether...
Yeah, there's someone at Christie's whose job is, I don't work for Christie's either, just there are other equally excellent auction houses, but there's someone at these auction houses in the market whose job is to value anything. And they get it wrong too. You hear about this. Oh, the so-and-so Klimt painting was supposed to go for $12 million and it went for $7, or it went for $50 instead. They're just guessing. They don't know. They can give you ballpark at best.
Just some more of the history. We're now at the end of 2006 in this point in the story. I've received some of Bob's email, actually not vice versa. That's actually wrong. Bob received some of my email.
Right.
Yeah. So it's kind of like if your phone number is close to the pizza place that's down the street, and you get some calls from people ordering pizza. That would, I think, accurately describe the nominal confusion. Bob at this point was fairly cordial and asked me about my statement on the website as he was receiving email from people telling him why I should own the domain rather than him, which was clearly intended to Fred, who was the previous owner of the domain, and I very promptly updated my website as well. So I updated and I said, please don't confuse me with Paul .com. That's a different Paul. I don't know if I could have said that any better. I don't know why there was such a big deal about that, but that's what my website said. You'll see that quoted in the press as well. So this is very important too. In 2007, Fred's website looked as follows, and basically was just saying that he provides marketing and project management, again, to speak to your point before. It remained this way from 2007 until December of 2011. That's another very important point, I think. In 2009, I asked Fred what would be the purchase price for Paul.com and never received a response. Things really heated up in around October of 2011 was the infamous phone call where Bob called me and essentially laid claims to the Paul.com trademark. And that's at the time when I called Batman. And then in December of 2011, Fred's website, Bob's website, looked completely different. Okay, it said Paul DOTCOM. It was a little trademark symbol, so there was a sharp contrast between what the website looked like in before December of 2011. So that made a very distinct change. Okay, and like I said, that's when I called Batman. I wish I had a red phone to call, from the Bat phone, but
we can arrange that.
yeah, direct line right to Batman, and we filed an official trademark application. During that process, in fact, right towards the end, Bob filed an opposition, which is when things started escalating. So yeah.
Quickly, when you file a trademark with the U.S. Patent, first point, Bob had not filed a trademark yet. Nothing. Okay?
Oh, so he has the TM.
Yeah, the way that works, let me explain how that works. I'm going to come back to that in a second. Okay? I'm going to tell you what TM means and what the other symbol means, and then I'll explain why in a minute. So if I can come back to that. The question was asked is what is the TM that she saw? Paul.com TM. When you see TM in front of a name, it means that person is laying claim to that as their property. Anybody can do that as long as they're in fact using that name in commerce. When you see circle R, that means our registered trademark. The circle R means they've filed it. You can't legally use circle R unless you have a filed trademark. You can use TM as long as you're just using it, period. You don't have to have a specific filing for that. This is as good a time for me to get into actually the reasoning for why that is, because it's going to become important in a second. In order to have legal trademark rights, you don't technically have to register it with the United States Patent and Trademark Office. You just have to be able to show that you've been using it in commerce. So this begs the question, if I register a trademark with the USPTO, and it turns out that someone before that was actually using that same name in my channel of trade doing the same thing, who wins? And the answer is that if you can prove that you have a prior continuing use of your trademark, that's actually stronger, ultimately, you have to prove it, than a registered trademark. Ideally, you want both. You want to be able to say, you registered it and you were first in use. Now, this is exactly what happened here, because when we filed the trademark for Paul, there is a period of time where the U.S. Patent and Trademark Office publishes the applications and says, hey, if there's anyone in the world that objects to this application, now's your chance. Because if you don't, you lose the opportunity. And Bob filed an opposition. He said, oh, wait a minute. I've been using that trademark.
On the last possible day that he could file.
So, next.
Whatever that's worth.
4.5 minutes.
I don't know why that was the case, but it was. So my assessment was I felt great. Like, hey, I was Paul.com, right? I've been using it since 2005. Everyone knew me as Paul.com.
In computer security, right? His use was always computer security.
I owned the domain PaulDOTCO.com before Bob owned Paul.com, and Kas can tell you why that doesn't really matter. I had hundreds of these episodes. My shirts and clothing said PaulDOTCOM, right? But unfortunately, or I guess not unfortunately, but in my case maybe, it's not a popularity contest, right? Just because I was popular in our security community and everyone knew Paul.com, to the U.S. and Patent Trademark Office, what does that really mean to them?
Well, I mean, it means that you were going to have to prove it.
Yeah.
Once that opposition came up, and Bob said, wait a second, I'm willing to start asserting the fact that I've been using this trademark before Paul, then it becomes a matter of having to go to the U.S. Patent and Trademark Office, have a lawsuit, get the lawyers involved, and actually figure out the fact pattern of who was first. I'm going to short circuit this a little bit and
Yeah.
cut to the quick just for timing purposes. In my legal opinion, okay, I have some wherewithal to say that. I do this for a living. Paul was right. There's no question in my mind that he had a virtually ironclad case. We could prove that Bob had not been using Paul.com in the trade channel of computer security that we had applied for. We could prove that he wasn't using that before Paul. He was right. What's the problem? For me, right, this. For me and my squad of trademark litigators to go in there and prove it was going to cost him north of $25,000. That's not even my money. I don't litigate. I'm the filer and I'm a business advice guy. I get nothing from that, but that also means I couldn't even offer to do it for free if I want to. The litigation part's not my area of specialty. It was going to cost him tens of thousands of dollars to prove his case.
And maybe even tens of thousands on top of that 25, because
It could have, yeah.
when you get into this whole litigation process, there are things you can do to slow the other person down and cause our legal team to have to spend more time, which eventually costs me more money, which was already starting to happen. The writing was on the wall that was happening in my assessment. So that's essentially where we were.
And I had to give my client this awful advice, which is, Paul, you're right. I think you've got an awesome case.
But forfeit.
How much do you want it?
Yeah.
If you're willing to pay that for it, if you think your brand is strong enough for us to do this, if you have a $10 million brand, then a $50,000 litigation is no big deal. If this is something that you don't have enough traction in the market yet that you're willing to pay tens of thousands of dollars to some lawyer to prove your point, maybe you should back off. That's not justice. It's horrible, and I still don't feel great about it. But I'm trying to purge my conscience by standing here in front of you and saying that's what happened. I mean, that's the truth, though. That's what happened.
One of the kind of funny things that happened in the case was in some of the documents that transpired between the two parties. There was this statement that in 2006, I wrote a blog post that admitted that Paul.com Security Weekly shows contained hacking stories, burping, farting, porn references, nipple shows, and all sorts of stuff that wouldn't fly in a personal environment. I thought the nipple show thing was really funny because I was trying to think like what is the nipple show? I think it's when like you weren't looking and I would hold my shirt up and say, "Hey Kaz," and then you'd look and my nipple would be in. So that was a nipple. So I thought I'd give a throwback nipple show. So that's my throwback nipple show.
This was not part of the presentation that the legal team approved.
Yeah. So, Kaz, I know we're running short on time, but I pulled this from the documents as well. And in 1994, it was stated that Fred registered Paul.com and began using the marks Paul .com, Paul .com, and Paul .com with no space in commerce. What defines in commerce? I think is an important for the audience.
Yeah, you have to be able to show some sort of materials that actually connect you to that name, to the service or product that you're selling. Whether it's a business card, packaging, a screenshot of your website, whatever it is that you do, massage services, if you can show your a PDF of document of your invoice or a calendar that you post at your business that has your name, we do massage services, whatever it is, that shows that you're actually using in commerce. You can't just sit on a name, think this is a great name, and not use it. They'll make you prove that you're actually using it.
Of course, proving it, as we said, can be costly. So I also thought, well, and we can probably skip this really quick, right? You couldn't register a domain as a trademark. If you use Google for legal advice, I caution you against that. Because I was like, well, I read on Google, Kaz, that you can't register a domain and then get a trademark for it. And he's like, no, that's not necessarily true.
Excuse me, just one quick second. So it's pretty much almost time, but if you want to take longer because only lunch is following us, go ahead.
Okay.
You guys, I mean, I want to give time for questions. You guys okay if we go 4 or 5 minutes over?
Okay.
Okay, if you get up and leave, you're not going to offend me personally. I may sue you, but that's...
So the question is, can you register a domain and then trademark the entire thing? Everything before the .com is typically what your trademark would be, but what if I want to trademark a domain, including the .com or .whatever?
The answer is it a trademark? If your business on the sign of your building says paul.com, that's a business name. Happens to also be a domain name. Now, if your business is Paul, and your domain name happens to be paul.com, but you're not doing business under paul.com, then it's not a trademark, right? So really, it's how you're using it. Almost anything can be registered as a trademark if you're using it to promote your business, assuming someone else isn't using it first.
This is your gobbledygook.
Yeah. Okay. So right. Very
I don't know how
quickly.
much you've covered
I told you, and listen, because so the public. Let's say you've been doing. Your family's been doing business for 2 generations under Business, Inc. And some joker like me comes up and registers a trademark doing what you do in Business, Inc. It's not fair for me to say, well, I'm savvier and I've got a good attorney, so now you can no longer run your business because I've got your name. That's not fair. So the rule that first use is important is a good rule. That's a good public policy rule. However, for practical purposes, once you register a trademark and the date of your application is on file with the feds, that's a really strong, bright line of, from this date forward, I got this. This is mine, unless someone prior to me objected, okay? So there's a good reason for filing these, even though someone might have a prior use. Or you never know if someone has a prior use. They might come out of the woodwork. The application process itself is not all that onerous, but you should know that there are absolutely strict deadlines during the application and afterwards. You do not need a trademark attorney to do this for you. It's not rocket science. But if you miss a date by a minute, if the filing date for something is 11:59 p.m. on a date and you do 12:01, you're done. You got to start from scratch and your date goes away.
Yeah, so Kaz, we filed the trademark for Hack Naked. We were awarded the trademark, but my job's not done to maintain that trademark.
That's correct.
So what happens?
So after you file your trademark and you are granted that trademark, someone opposes or you win, or then no one opposes, 5 years after the first filing, you have to, within 5 years, actually it's between 5 and 6 years, you have to file again with the USPTO and show, yeah, I'm still using the brand name. After that, every 10 years, you have to file again to show that you continue to use the mark. And if you miss one of those filings, someone can sneak in.
Does that mean we need to keep hacking naked?
I'm afraid so. Keep hacking naked. So,
so I just do it in summary, right? First use in commerce, first to file, and then the channel in which you're filing in are the important criteria that
and maintenance. We call it the maintenance is the sort of periodic filings. Yeah. Now, questions? Yes.
So Fred didn't file a trademark either, so why do you have to change your name?
Excellent question.
Good question.
Right? So if Fred owned it and then Bob owned it, where does the trademarkiness begin?
Yeah. So if Fred had been using Paul.com in computer security and not registered, when he sold that name to Bob, and Bob had hypothetically continued to use that name in computer security, the two uses merged together. Bob would have the benefit of Fred's start date. It's a great question. It's a very good question. The issue here is that neither Fred nor Bob were in computer security before Paul. That's a fact.
So you don't have to change your name?
Well, the point is that the question is we'd have to fight it at this point.
And that was my whole hacking the trademark system, right?
Interestingly, now Bob has finally filed the trademark you've changed your name, but we're talking about whether we should file an opposition just to stick it to him.
Yeah. So so here's the so it was in the press, which was kind of interesting. So all this is parts of it are public knowledge. So I just wanted to point that out as well. And then we kind of talked about that. Not all cases end up this way. So the current status, right, is Paul, period, com, so Bob opposed. And the hacking part is, right, because Bob owned a domain, he had some stuff on that domain, and was continually pushing it and challenging us at every step of the way. That costs me eventually money, right? And can push that to the point where I'm like, I don't want to pay for this anymore. It's not worth it. I'm going to rebrand. So
Furthermore, and let me put it this way. Ultimately, your brand name is something that you want to derive value out of for yourself. And you don't want to fight with someone else about it. You don't want to share that value. Let's say our Paul had created a mega monster company, Paul.com, out of the sweat of his brow and working his business. And ultimately he wants to sell his business, sell his domain name. Someone comes up and says, I'll give you $10 million for that domain name. They do their research and they figure out there's all this trademark litigation. Someone claims ownership to it. They're going to go,
no, that's a great point.
you know what,
That was another reason too.
I'm not really that interested.
Yeah.
So Paul made a hard decision, I think probably ultimately the right decision financially, to say I'd rather put my efforts into a different trade name that I know that I've got this. And we, Security Weekly, we've filed, we're good, and that's now where he's going to build his value.
So I'm sorry, Paul period com, they're published for opposition March 25th, right? There's 1 month from being published from opposition where anyone has their last chance to oppose.
Right.
So that's what that means. So Trademark will become live essentially April 25th.
I want to make sure we get to questions, yes.
Yep.
Can we have you use the mic for the questions?
Sure, go ahead.
So you filed the trademark application,
Yes.
and then he filed an objection, and that meant you couldn't use it anymore?
I could use it, but I could not be awarded the trademark for that name.
But
That's correct. He could continue using it.
Using it
That's
until
right.
he filed this, and then you would
That's right. He filed this, and we could object to his potentially, or if he files this and we don't object and he gets the trademark, then he comes back at us after the fact and says, well, I want you to stop using Paul.com. Then we say, well, no, we were prior in use and we have to prove that. We're in court again. He wins. He's totally right. At the end of this process, if money is not a factor, I got his back. He wins. The point is that it's very difficult, if not impossible, to go after Bob for legal fees. That's the point.
And it's not a very good investment. I mean, if we do win, right, there's this whole backstory that could potentially devalue it down the road.
But you didn't actually have to stop using it. You chose to stop using it because you wanted to.
That's right. He could continue to use it now, but with the knowledge in the back of his head that Bob might be somewhere in the future.
Right. So we have stopped. I'm sorry.
Well, there's no ownership. We never got the application.
But that's a good question. So the domain, pauldotcom.com, I still own it.
Right.
We could talk legally about how that could transpire, but
Are you worried about any loss of credit for any intellectual property published under now? Like, are you going back and cleansing your records to update it to something more
different
personal?
body of law. Anything that he would have published would be protected under copyright law. Still totally belongs to him. It's not as if Bob could now come forward and say, I own the content, that a non-issue.
Well, more a question of taking credit for, people going to look for your sans.
Right. Well, we're not entirely sure Bob is that. I'm going to stop there. Last question. Maybe one more. Anyone? No, we caught them all. Okay, if you have any other questions, you want to see me afterwards, I'll stick around for a few minutes. Thank you all very much. I hope you enjoyed it, and I hope you got something out of it. So,
thank you.
It seems like you like to talk. Please fill out the evaluations. So